3:30, the car comes up the driveway. The defendant's driving. He's still wearing that white shirt. He gets out of the car. The other two get out of the car. And what is noteworthy in terms of, again, grand jurors being in the best position to determine what inferences to draw was the surveillance there and the behavior of these three individuals. Nobody appears to be upset, surprised, shocked. In fact, it's a nonchalant. They get out of the car. The defendant actually turns around and begins to fish in around the area of his seat. And we know later on there was a shell casing that was recovered from under his seat. At least they could infer shot being fired from inside the car. Now, after they get out, the three of them move together. They go into the home. At that point, the defendant, again, he was observed leaving with the firearm and is now seen with the firearm again. Nobody else is seen with the firearm. They then go, as they move through the house, they go to the basement, and he's last seen with the firearm before he goes down into the basement door. The testimony showed that that surveillance system had been installed within about a month or two of the homicide. At the time it was installed, there was some conversation the defendant had about not wanting to have a camera in his, what they referred to, the man cave in the basement. He was then told how to disconnect that, and sure enough, within a couple of minutes of him leaving sight of the basement, that system is shut off. It's shut off for a number of hours till the next morning when it comes back on again. At no time did the firearm, is there any suggestion, at least on the video, the firearm moved out of that basement area. In fact, later on there was testimony by an individual who said not only had he seen a firearm in the home, he had seen it in a metal box in the basement. The three are then observed in the course of the day at the home. Now, as the hours are moving toward the afternoon, at some point they go outside. The vehicle, when it left on the defendant's own home camera system, even on Fayston Street, when it came down, that driver's side mirror was intact. There was nothing wrong with it. When they return from the drive, the mirror is broken. And again, the grand jurors would have perfectly been in their right to conclude, and when I had earlier suggested that this was a pretext, that it was the defendant who had the relationship with the victim, who had this prior incident, who made all the arrangements to get him there, that he was the one who had set the thing up, driven it, made it happen, brought it to its completion. And in fact, when he came out, there's some observations of them looking at the mirror, and at that point, the three of them get into the car and then drive over to the Enterprise. Well, initially, he had, according to the Enterprise manager, he had said this car was going to be rented for a month. In fact, he turned it in on that date for a different car. He then returned to the home with these other two, and at that time, the other two then left. Now, with regard to the evidence, which you and as well the grand jurors could consider and draw reasonable inferences from that evidence, as to the consciousness of guilt of the defendant, there were numerous indications of consciousness of guilt that would also suggest an intent to see that the purpose, because not only the planning, which I've indicated was wholly set up by the defendant, but also then the execution of the plan. Again, the production of the gun, the deliverance because they could properly conclude that despite his suggestion they were going to step out again like they had to a club, and then the reluctance of Odin Lloyd saying, well, nothing's essentially open, is that they drove for approximately 2 hours and 15 minutes. They left, it was approximately an hour and 15 minutes to an hour and a half to go pick him up, and then immediately return right to the spot where he was killed. And again, the route of travel consistent with the time that they drove, even running through tolls to essentially get to the location. But the consciousness of guilt is that the defendant then permitted, I disagree with the suggestion that just mere presence. There's the evidence would suggest presence, knowledge, and an intent to see this thing through based on all of the evidence and his setting it up, this almost frantic earlier in the night about the texting back and forth and the calls about where are you, get your ass up here, that he wanted the purpose of this thing to be complete, and it was.